Yes, Tarang, you can start.
Good evening, everyone. I am Tarang Arora, Junior Content Editor at Jus Corpus Law Journal, and the host for today's session. I, on the behalf of whole team of Jus Corpus, welcomes you all to today's session on key aspects of shareholder agreement. Before we delve into today's discussion, let me brief you about Jus Corpus and the eminent guest of today's session. Jus Corpus is an edtech platform established in 2020, comprising a collection of legal professionals. The platform aims to consolidate various aspects in change of law under a single umbrella with an impressive reach, averaging 100K clicks per month on its website. Jus Corpus was inspired by growing needs of law students. As part of its initiative, Jus Corpus has introduced an interdisciplinary journal known as Jus Corpus Law Journal. Now, turning our main attention on the focal point, we are privileged to have Mr. Akshay Pathak sir as our eminent guest speaker of today's event. Sir currently serves as a principal associate at SAM. His expertise lies in domestic and cross-border M&A, allowing the focus on general corporate matters, including restructuring. A graduate of Amity Law School, Delhi, Sir brings a wealth of expertise in on table. Prior to his current role, he served as an associate link legal for approximately 3 months, and then served as an associate at SAM for around 2 years. In October 2018, he joined CAM, and additionally, he holds an advisory position at Just Corpus Law. Without further ado, I would like to hand over the floor to Sir for insight into key aspects of shareholder agreement. Over to you, sir.
Sir, I think you are on mute.
Yeah, hi. Thank you for the kind introduction. So today, as previously mentioned, we'll be discussing on key aspects of a shareholders agreement. So without wasting any time, I think I should just straight away start. So for clarity purpose, before we delve into the essentials or the main components or the basic nitty-gritties of a SHA, it's very important to first understand what exactly is a shareholders agreement. As the name suggests, it is inter se an arrangement or an agreement between the shareholders. Like any layman would also understand that it's a arrangement between the shareholders, but it's not as simple as the name suggests. First and foremost, it's very important to understand why is it executed, and I would try to simplify the discussion and the points which I discussed, so that even people who are very new to this concept, obviously there would be people who already have some bit of idea about this agreement, how this, what is the use of this agreement. But it's very important for even law students or those who have never even seen a shareholders agreement to have some idea that why is it executed, what is the purpose, right? Before going into the different clauses. So as the name suggests, it's an arrangement between shareholders. Now, important question, which is very important to understand, is that why is it executed? So I'll explain this with a very simple example. Let's say you and your friend, and I'll keep on giving very simple example, which may not be very ideal in uh, uh, in a uh, in commercial sense, but for understanding, it's I think that those examples would do. Like for example, you and your friend start up a business. Okay, you and your friend set up a business. You infuse money into the company. Obviously, there are multiple ways of infusing funds. That is not the point of discussion. I'll try not to deviate. I'll stick to shareholders agreement also. You only you guys incorporated a company, put in money in the company. Now you started running the show. Okay, and it's a startup. Let's say it's a edtech startup. Okay, you are selling courses to students. Okay, now your business is growing as you are day to day on a day to day basis. You are functioning. You're providing your curating courses for maybe law students, and you're selling those courses to law students. Okay, your business is growing. Now, uh, obviously, you are getting decent amount of money, but let's say COVID came up, and now you are out of money because people have stopped taking, maybe for some reason students are not taking up courses. Your business costs are high. Maybe you have also hired some employees to help you guys. to curate courses, and maybe you have a marketing team, sales team, which helps you in selling those courses. Obviously, a business has some costs, right? You can't not have those costs, associated costs with it. Now you're out of money. You can't just shut your business because you have put in a lot of effort into your business. Now, what are the options available? One option is that you shut your operations, right? Obviously you don't want to do that. Other option, or the only solution left, is that in some form or the other, you want money into the business, right? Neither of you have that kind of capital. Independently, you don't have that kind of money. Then how will you fund the business? Obviously, you would want some new entity or some new person or a company to put in money into your business, right? If some other person is putting money in the business, how will it happen? It will either be in form of loan, which obviously you'll have to repay it back, right? And obviously the person would also want to charge some interest, right? Maybe that you are not in a position to do so. Okay, you're not sure whether you will be able to pay the loan back, or that is not a feasible option considering the your considering the commercials or the financial position of your company. So what happens is that now you come across a gentleman or a person or maybe another edtech company, which maybe is offering not exact services, but it has certain expertise which you think will enable you to reach to or scale to greater heights, right? You approach that entity and they're okay to partner with you, and they are up on one condition, that they will give you money not in form of loan, but they would become a partner in the sense that they will also hold some share in your company. Okay, I'm explaining as if someone who has no clue about the shareholders agreement will be able to understand some bits of it after this 1 hour discussion ends. Okay, so now this gentleman or a company, a tech company, which is not offering exact services but maybe similar services, and it has its technology is maybe better. It has some on some points you feel that it has an upper edge, and what it will bring onto your table, that'll help your business to scale to greater heights. It is okay to infuse money into the business provided that you give it some equity. Obviously it won't give you money for free. Okay, now it gives you money, right? Now how will that happen? You will execute, and obviously all these are commercial things. Now between you two maybe were brothers, maybe you were very good friends, everything was fine. There was no room for conflict. Even between brothers, friends, there can be conflict, but you guys had some soft understanding about the functioning of the business, right? There was no scope for dispute. You knew that between yourselves you will manage. Now if a third person comes into picture, which is a shareholder, right? You two were also shareholders of the company, maybe 50-50%, maybe 60-40%. Now a third person also comes into picture. That third person will also have some say over the affairs of the company. Let's say that person subscribe to shares, which is giving it the a 30% stake in the company, right? Or maybe it didn't subscribe to shares. It bought some shares from both of you. Maybe you both were holding 50-50% stakes. Okay. Now this third person buys 20% stake from both of you. Okay, let's say A and B, you are holding 50-50. Now this C buys 20 from A. Now A is left with 30 and B is now left with 30, 20-20. And now C is holding 40. Okay, simple. Now it is holding 40% stake in the company. Now, obviously it's a new party. You would want to have some written arrangement with respect to the governance of the company. Now you would say, why not just agree orally? I'll give an example. Let's say with respect to the functioning of the company, you guys had decided that, acha, we are A and B, we are holding 50% stake. We both will be directors on the company, A and B. Okay. Now, just imagine a third guy is entering into the picture, which will now hold 40% stake. And you guys are holding 30% stake. How can you not, and how can the person who's entering into the business with you, partnering with you, putting money or putting money in the sense that they have let's say, again, in this example what I gave you, technically it's not correct, because see, what the first example which I gave you was a situation wherein your business needed money, right? There was no money in the business, so the person puts in money in the company. But this example which I'm giving you, that is a case wherein C is buying shares from you. So when C buys shares, the company will not get money, you guys will get money. So let's keep this example apart, because in this example what will happen is that when C buys 20% stake from you guys, company will not get money. Your shares are being bought, you will get money. So ideally the first example which I gave you, that will work in a situation wherein the company needs money, right? But it means the same. I wanted to give an example whereby a third entity comes into picture. It can be either by way of subscription, or it can be by way of share purchase. Okay, it can be by way of share purchase. My idea was to just let you know that a third entity comes into picture, either by way of share purchase or by way of subscription. Okay, so I just wanted to let you know, so that in case there's no doubt with respect to the fact that if the business needs money, then it can't be by way of share purchase. If the business is needing money, someone has to put in money in the company and not merely buy shares from the existing shareholder. Keeping that discussion apart, some third parties coming into picture, and that has, like, let's say 30%, now 40% stake in the company. Now if that entity has 40% stake in the company, obviously that entity would want to have certain rights over the company, right? It's very logical that a 40% shareholder must have certain rights over the company. And now what kind of rights would you want to have? Just logically think that if you're holding 40% shares, what kind of rights would you want to have? Number one, you would want to have control over the affairs of the company, the day-to-day functions of the company. Now, how will that happen? That can happen only and only, first and foremost, if that person has some control over the board, right? If that person has some control over the board, right? Now, for having control over the board, that person must be appointed, or that entity must have a nominee on the board, right? Because under company's law, a board is responsible for the day-to-day operations of the company, right? So the entity which is infusing money or buying certain shares would want to have control over the board. It will want to have directors on the board, right? Okay. Then the second point being that obviously that entity would want to have certain control over the company contractually also. Now you'll ask, what kind of, you already have some control over the company by way of board seat, then what kind of control do you have? I'll give you another example. That entity, you guys are into edtech business, okay? That entity or the person is also into edtech business, right? Agreed? Now, would that person be comfortable with you guys going ahead and getting another person on the cap table? By cap table, just to simplify, let's say now you three are working together, A, B, and C. You guys have a company. C also has a separate company, okay, and doing similar kind of business, and they are okay with putting money into your business, right? Would C be comfortable in you guys getting to know all the technology with which C uses in his or her company, or C being the company, okay, using that business for the company, for your company? Let's say your company's name is ABC Tech Private Limited, okay, and then using the same technology, doing well, and then getting a competitor, C's competitor, let's say D. D is C's major competitor, okay. Would C be okay with you guys going ahead and letting D subscribe to the shares? Maybe not, right? The entity which is giving you money or joining hands with you for its growth and your growth Maybe it is giving you technology. Maybe you are giving something else to them. It would not want your company or its own company together, you guys, in any way joining hands with a fourth competitor, right? So it would want to control all that. How will that happen? That can happen only with when there is some restriction on share transfer, wherein it's documented that you can't sell shares to ABC, my competitor, or whatever. One example is this. Similarly, I hope all this is very clear. Similarly, the person who has put in money or has joined hands with you by buying your shares, some amount of shares, would not want that, may or may not want you guys selling shares to some third party and diluting its stake. Now you'll say, what is dilution of stake? Very simple example I'm giving. Let's say now after this subscription or whatever, you are A and B are having 30% each. C is having, let's say, 40%. Okay. Now if let's say you guys go ahead and issue shares to some new party, obviously your inter-se shareholding will go down. If D is issued shares, entitling it to 10%, then proportionately A, B, and C's shareholding will go down, right? Because some new person is subscribing to the shares. And maybe C has certain rights linked to its shareholding. Let's say you guys have decided that C will get XYZ rights only till the time C is holding 40% stake. It may not want its shareholding to go down, right? It may say that, look, if you want money, you please ask me. If the company is looking for money, you please don't go to third parties and just ask them to subscribe to shares, and which will lead to my shareholding going down. Please come to me. Okay, please come to me. I will give you money. I will subscribe to the shares, right? So I've given you 2-3 examples as to why a written understanding is needed. So that is the sole purpose of a shareholders agreement. As I said, a shareholders agreement is an inter-se arrangement between shareholders of the company, which determines the mutual rights and obligations of the shareholders. Okay, understood? Now, this is the main purpose of a shareholders agreement. And I think someone has commented about a one-person company. I just saw in one of the comments. It's okay to keep on getting the questions as and when they are, because ideally the main purpose is to simplify the discussion and so that people understand. The idea is not to give a monologue. So see, in a one-person company, you wouldn't need a shareholders agreement, right? Because it's just it's a one-man show. A shareholders agreement comes into picture when there are more than one shareholders, maybe 2, 3, 4, so that there's no confusion with respect to the rights and obligations, right? Now coming to the key clauses of a shareholders agreement. Just to caveat this discussion by saying that, see, I'll be discussing the key clauses, but there are n number of permutations, combinations in a shareholders agreement. Whilst I can give you a broad overview of what a shareholders agreement could look like, but it is not as simple as I would try to make it. And there could be n number of permutations and combinations with respect to an agreement understanding between the parties, right? Now coming back to the discussion. Now, a shareholders agreement typically will have an effective date clause. Now, again, what exactly is an effective date clause? An effective date clause primarily would be the date from which the agreement would come into effect. Now, you would ask, we didn't understand. Why do we need a date, and what a date exactly is it? So typically what happens is that a shareholders agreement would be executed in 2 scenarios, where either there's a share purchase agreement happening where a third party is buying shares, right? Or the existing shareholders are maybe multiple scenarios, not just 2. Maybe the existing shareholders are changing their inter-se rights and obligations, or maybe some third party is subscribing to the shares. So when that subscription or the purchase happens, when the actual money comes to the buyers or the money comes into the company, that is considered as the closing date, when the transaction is consummated. So typically a shareholders agreement would come into effect on that date. You may agree that within 60 days, I will put in money, XYZ will put in money, XYZ will buy shares. But when the actual subscription purchase happens, that is when the agreement will come into picture, right? You may agree on anything today, but the clauses will get effective only from that date. Understood? So that is an effective date clause, right? So a shareholders agreement would say that this agreement would come into effect from the effective date, which would be the closing of the transactions under the SPA or the SSA or any transaction specific documents which you are referring to. But there are certain clauses in a shareholders agreement which would come into effect on the date on which it is executed. Okay, like governing law clause, notice clause. If let's say there's a dispute even before the money comes in, right? How would that be governed? That still has to be decided, right? So those kind of clauses come into effect on the date on which the agreement is executed. So just to repeat, you may sign on the agreement today, but it will always, and in most cases, become effective on the closing date when the transaction is consummated. And if no subscription happens, no share purchase agreement happens, let's say A, B, and C, you guys have decided that C will put in money on the date you executed the agreement, but C doesn't go ahead and subscribe, then this SHA which you have executed today will become redundant. If the closing doesn't happen, you'll have a clause in your SHA that if the closing doesn't happen, if C doesn't subscribe to the shares, then it will get redundant. You wouldn't want C to be a director, to nominate a director on the board of the company if C ultimately doesn't purchase your shares or doesn't subscribe to your shares of the company, right? So that is the effective date clause. Now, obviously, it's not possible to delve into all permutations and combinations, but key clauses I would want to discuss. The most important clause would be share transfer restriction, which I briefly discussed, that if you guys A and B are parties to an agreement, are shareholders, and then C comes into picture and C may not want you to transfer your shares, right? All that in brief I discussed so that you get some bit of understanding. So that is what I would want to talk about and discuss, right? So now coming back to the discussion, share transfer restriction. Share transfer restriction are restrictions on share transfer, which would restrict a party from transferring any shares. And the shares can be transferred only and only when certain conditions are met, right? So from that perspective, someone has asked that, is it like an arbitration agreement? See, a shareholders agreement is not like an arbitration agreement. Arbitration agreement is something else. A shareholders agreement, arbitration agreement is for a dispute with respect to arbitration. A shareholders agreement is an agreement which is even before a dispute has happened or parties are not contemplating a dispute. Whilst a shareholders agreement will have a governing law and arbitration clause, but a shareholders agreement inter se discusses the rights and obligations of shareholders with respect to a company. Okay, this was just to answer a question because I just noticed that someone had asked. Okay, now coming back. Now, share transfer restriction clauses, I'll give example. A very important clause which you would have heard of, or if you are working in a law firm, or maybe working as an in-house counsel, or maybe you are doing your internships, you'll keep on hearing these clauses: ROFO, ROFR, tag, drag, call, put. Okay, ROFO, ROFR, call option, put option, tag, right, drag, right. So these key clauses I'll discuss. So ROFO, right of first offer, is ROFO. Right of first refusal is ROFR. Now, as the name suggests, right of first refusal would be a situation wherein I'll give very simple examples. If you want to write, make notes, feel free, or it's a very simple example. Even if you Google, I'm sure there would be a lot of literature available. Now, I'll give very simple example. I'll not use technical jargons to discuss. Now, let's say A and B are holding shares. Okay. A wants to sell shares. Okay. A wants to sell shares. And assume that B has ROFR right of first refusal. Okay. B has ROFR right. So now if A wants to sell shares, A will go to some other party, offer its shares. Some other party will offer price for those shares to A. Now A will come to B and tell B, look, I went to the market and this is the price which I have been offered. Do you want to buy my shares? And A is obligated to offer the shares to B. Now, if B is able to offer the same price or more price, what some other third party has offered, then B can buy those shares. B has the right, not the obligation to buy those shares. So B has a ROFR. So if B has the ROFR over A shares, in that case, A will find a buyer. And if B is able to match that price or pay more, A will be obligated to approach B. Okay. And in that case, B can buy the shares. This is ROFR. Now coming to ROFO. In ROFO, assuming same example A and B, B has a ROFO. In this case, if A wants to buy, A wants to sell shares, A will go to B and tell B that B, I want to sell my shares. What price will you offer me? B will say, I'll pay you X rupees per share for itna number of shares. Now, A has the right to approach some party, and if that party is able to pay A more, okay, if A approaches a party and someone approaches a party with the price which B offers, and A is able to get a better price, then A can go ahead and sell the shares. So the difference between ROFO and ROFR is that in ROFR, the price discovery has already been made. Okay, if B has ROFR, then A already brings a price. A already brings a price, right? Okay, A already brings a price in ROFR, but in ROFO, there's no price. Okay, if B has ROFR, B will offer a price. A can go and get a better price. This is the difference between ROFO and ROFR. Okay. Now coming to call option, put option. Call option is a right wherein, let's say again example A and B. If A, let's say B has a call option. If B has a call option, then upon happening of XYZ events, which will be documented in the agreement, B can ask A to sell its shares to B. If B has call option, B can ask A upon happening of whatever events which are documented, B can ask A to sell A's shares to B. Put option is totally opposite. Again, A and B. If B has a put option, B can ask A to purchase B's shares. Other way around. In call option, if B has the call option, B can ask A that you sell me your shares. But if B has put option, B can ask A, you purchase my shares. This is put option. Now let's come to tag and drag. I'll give very, very simple example. I hope till so far it is very clear. Tag and drag. Same. A and B. B has tag right. Tag right would mean it's my right. It's not obligation. B will say, A, if you are selling your shares to some other party, that other party will also have to buy my shares. I'll repeat. A and B, two shareholders. B has a tag right. I'm giving very simple examples just for basic understanding. I'm not going into very complexities when it gets triggers, blah, 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 details. If B has a tag right, B will say, it will be documented that, look, boss, A, if you're selling your shares to some other party, then that other party will also have to buy my shares. I will tag along with you. I will tag myself. Now, same example, I'll give drag right. A and B. Okay. B has a drag right. Now, if B has a drag right, B will have the right to tell A, look, boss, I am selling my shares to some third party. I will drag you. I will force you to sell your shares. You also will have to sell your shares to that third party. I'll again repeat. A and B. Now, B has a drag right. Earlier, B has a tag right, wherein B said that, look, boss, A, if you're selling your shares, you also ask the third party to buy my shares. That was a tag right. Drag right is a right wherein B is selling its shares and saying, look, boss, I am selling my shares to a third party. I am dragging you. You are also forced to sell your shares to the third party. This is a drag right. Understood? Tag, drag, call, put, ROFO, ROFR. Very simple. If you just take that example A and B and remember it, it'll be very clear, at least from a ground level perspective, from a basics perspective. you will always remember this. I hope this is clear. Okay. Now, these were share transfer restrictions. Now, one important key right which I want to discuss is further issuance. See, I'm not discussing all clauses. I'm just clarifying. It's not possible to discuss all nitty-gritties of or complexities of a shareholders agreement at one go in one discussion, and it'll be too much to absorb. Also, we can have another session if time permits and if people are interested. That is also important. Okay. So now going into further issuance or preemptive clause. That this example also in a very crisp way I had given. That same example I'm giving. Just remember the examples A, B, C will be very easy. That same example I'm giving, that there are two shareholders A and B, then the new guy comes C. Okay, let's say or let's say you just have two shareholders A and B. Preemptive right is a right wherein, let's say, two shareholders A and B. You guys have 50-50 shares each, 50% shares each. A preemptive right is a right wherein if the company needs further funds and if company is issuing shares, okay, the existing shareholders will first get a right to subscribe to the shares so that their shareholding is not diluted. Very logical. If you guys are holding 50-50% shares, the company needs money and some third parties is subscribing to the shares. Obviously, your shareholding will get diluted, it will go down. Preemptive right says that company needing funds, if the company is issuing shares, the shares will be first offered to the existing shareholders. This is a preemption right. As simple as it can be. Okay. I'm again not going into too much details. Now, other important clause in a shareholders agreement would be affirmative vote right or a veto right or a reserve matter related right. All these terms are used interchangeably. It is very important to know. Okay. I think there are some certain questions also. I'll try to discuss those also so that the questions are also taken care of. So again, I'll repeat. There are other important clause which I want to discuss is a AVM list, affirmative vote matter list, or a reserve matter list, or a veto matter list. These terms are used interchangeably. Okay. Now, what are these lists? So basically, these are negative powers given to an entity to control the affairs of a company and to prevent something from happening. A very layman kind of example. This thing I have given, a definition I have given. I'll explain with the help of an example. Now let's say there are three shareholders A, B, and C. Again, that same example I gave. Okay, they are holding like 40, 30, 30% shares. 40, 30, 30% shares. Again, the company needs money. Okay. Again, the company is needing money. It wants to it's okay with letting some other third party subscribe to its shares till the time the company gets money. Right. Now, ABC are able to locate D, which is willing to subscribe to shares. But it's willing to subscribe only a nominal amount. It is not willing to nominal shares, and it wants to sit on the cap table and have, let's say, 10% shares only. Right. Now, D puts in money in the company, now has a 10% stake in the company. Okay. And ABC are proportionately reduced. Basically, A, B, C still have a decent amount of stake, but D has just 10% stake in the company. Okay. Right. But D came at a time wherein the company needed funds. And D is also a strategic partner. It is also an edtech player, which is bringing some amount of expertise on the table. It's not just a random entity. Now, in that situation, D would still want to have certain rights over the company, but commercially it's discussed that D will not have a right to appoint any director on the board. So basically, D is not getting any board seat. Okay, D is not getting any board seat, whilst D is bringing something on board with respect to technical expertise or maybe more customers or maybe whatever. List goes on and on. But D, it has been commercially agreed that D doesn't want to be part of the board, or maybe A, B, C don't want D to meddle with the day-to-day affairs, or for whatever reason, it has been commercially discussed that D will not have a board seat. Now, but at the same time, D still wants to have some control over the board. D again doesn't want you guys to go ahead and maybe sell all your assets to a competitor. D is just holding 10% stake. D cannot, if you collude together and um, decide together to sell the assets of the business, they won't be able to do anything, right? Maybe you guys go ahead and sell it to some random party, sell off your stake and run away. You guys will still have like you sell all your shares and or the assets of the company, and you all will be more than happy. But D is not into this business for a short term, right? D is not okay with that, right? So D will still have want to have certain control of the company, but for pursuant with shareholding, it cannot block. It is not in a position to block all matters, right? So this is where affirmative vote matters, veto matters, AVM matters come into picture. These are interchangeably used terms. You will hear them often. People get confused that these are different terms having different connotations and meanings, but more or less these are same terms. Now, AVM list or veto matter list or affirmative reserve matter list is a list of matters which is giving a negative control to a person. So those actions, if a party has a veto, it's a veto right over a matter. It's usually a list of items. In SHAs, it's usually a list of items. Okay, so over those list of items, one party, let's say, has a right, a affirmative vote right. Then those items, those action items cannot be completed without the consent of that party. Okay, now let's say it's a list, or let's say there are items. One item is changing name of the company. Number two, sale of material assets of the company. Number three, merger of the company. Okay, there are three items: change of name of the company, sale of all the assets of the company, merger of the company. So these things can be approved. Let's say D has no right over the board. It doesn't have any boards. So these items can be approved by the board, but in all probabilities, D has to say a yes. So D can't initiate these actions. If D wants the company to change its name, it can't initiate an action. But yes, if the company's name has to change, then for sure D's consent will be required. So D has a negative right, a negative control. D can say no, and that action item can't happen, right? Just to simplify again, that if the name of the company has to change, D can't say that, tell to the board, or D can't initiate an action that I want to make change to the name of the company. But yes, if A, B, C on their own decide to change the name of the company, they can't do it unless D's consent is taken. And this is one of the examples. It depends on the item. It can be a long list, it can be a short list, depending on the commercials. I gave three examples, three items I gave: change of name, merger, sale of assets, material assets. So these action items which are in this AVM list, and if D or whatever party has a AVM right over that list, or whichever party, it's written that those action items can't be, if it's written that D has a right, AVM right, then those action items can't be taken, that they can't be done at board level, shareholder level, unless D's consent is taken. So this is an AVM list. There's something very, very critical. It's a minority protection right, which is available. Okay. Now, broadly, transfer restrictions, AVM are one bucket. There are other clauses also. Like, for example, typically in a SHA, you may also have a waterfall with respect to funding. That how would the funding happen? If company wants funds, how would the funding happen? Typically, it's important to have a water flow. By water flow, I mean steps. First, you will use your internal accruals, whatever profit you make. Then maybe go for debt financing. Then if that is also not possible, or you want more funds, then maybe go for financing through equity. That is one point. Then in a shareholders agreement, you'll also have, you may or may not have, depends on your transaction, anti-dilution clause. Anti-dilution clause says that if funding happens, funding by funding I mean if the company is issuing shares at a lesser price than what it issued earlier, then uh, the person having anti-dilution protection would be issued shares free of cost to prevent it from being diluted. This is one of the clauses which a shareholders agreement will have. Preemption I have discussed. Then obviously one important clause which I would want to discuss is a governing law and dispute resolution clause. Typically, if parties are Indian only, then you have governing law would be Indian law, and obviously dispute resolution you would want to save cost. You will say that the dispute resolution would be governed by the uh, Indian Arbitration Conciliation Act. And if one of the parties is foreign, maybe they would want to go for SEAC, right? Now, which is Singapore arbitration. And one thing which I want to clarify is the difference between seat and venue of arbitration. A lot of people keep on getting confused, and especially at when they've just joined their organizations, they've just joined a chamber, or they've just started the practice, or just started interning. That what is the difference between seat and venue? You will see in agreements that the seat and venue of arbitration shall be XYZ, or the seat shall be X, venue shall be Y. Please understand, venue of an arbitration can be anything. It can even be a home. Doesn't matter. Venue is just a place where arbitration is taking place. Seat is the place whose procedural law would be applicable for the arbitration. Always remember, I'll repeat. Venue of an arbitration can be anything. Seat of the arbitration is the place whose procedural law would be applicable uh, uh, for the arbitration. Now, let me just see if I have questions which I can take up. Should the chairman of a shareholder meeting or a board meeting have a casting vote? See, this is something which typically you also mention in your SHA. That see, casting. I just for your background, for those who don't know what is a casting vote. A casting vote is a way to break a deadlock upon equality of votes. Okay, when if the votes are equal, then what will happen? If the votes are equal, then what will happen? There'll be a deadlock. A decision can't be made, right? So casting vote is usually given to the chairman so that he can break whatever he says. He'll have the final say, right? So from that perspective, a casting vote is usually people prefer not to give casting vote to chairman, but it's something which is commercially discussed. Okay, so that is it. I've usually seen that people specifically write the chairman will not have a casting vote. Should all shareholders have voting shares? Should any shareholder or group of shareholders have the veto rights to certain decisions? Yes. So that's what I explained, that some shareholders can be excluded from having AVMs, and specifically only some shareholders can be given a veto right. That example which I gave, wherein D had the AVM right, veto right, and D can block certain decisions. Okay. Can merger and amalgamation change power of shareholders? See, merger and amalgamation is obviously, if a merger happens, then it's sort of a restructuring for a company, right? Then that SHA may not even subsist, right? Then hello, this is any role of a director in this type of agreement, even if people are from the same family. Example, father is a shareholder and son is a director in the same company. A father and son can be director. That is, see, if you're a director, there is a provision under the Companies Act, Section 166, on roles and duties of. Sorry, I'm digressing, but since it's a question, I think it's important to touch upon this aspect. See, a director has a fiduciary duty. Okay, a director has to act in the interest of the company and its shareholders. Okay, so even if father and son are the directors, they should not idly collude together and act in their own interest. There are certain provisions under the Companies Act which also give right to the shareholders to reach appropriate forum if they feel that the directors are running the show only for their personal benefit, right? If you read more upon operation mismanagement, you'll come to know. A father and son can very well be a director, and there are so many promoter-driven companies who have father and son duo as shareholders and also as directors. There's nothing wrong in it. Okay. Uh, if there any arbitration I have discussed, share transfer restriction was something very, very major which I wanted to discuss. There are certain other aspects also, like if it's a business wherein you would want to discuss the expenditures and your growth aspects, you would also want to have a business plan in place. You would want to, if it's a new business, if you want to, or a new entity has come into picture, let's say D entity is a fund and it's very particular about the entity in which it invests. It would want to have a systematic investment plan in place, and it would want you, the promoters or the founders, to show how it will run its business. So it's best to have a business plan, okay, and mention in the agreement particularly that the company will have a rolling business plan which will be prepared every year or every third year, and maybe annex the first business plan to the shareholders agreement. Okay. Then obviously a shareholders agreement will also have a termination clause which will stipulate when an agreement will terminate. And this is a very important clause. Number one, the agreement has to come into effect only when the subscription or the share purchase has happened, when the closing has happened, when that person for whom you are executing the SHA for governing the rights and obligations has come into picture, right? So if that subscription doesn't happen, then obviously the SHA falls off. Falls away means if it doesn't happen, then it has to terminate. Then also you will have to specifically mention that it will terminate for a shareholder upon it ceasing to be shares in the company. If D doesn't have any shares in the company, then why will this SHA be applicable on D? Right? So that is also important. Then there are certain also ancillary rights which are available to shareholders, which are documented in a shareholders agreement, like information and inspection rights. Same example, let's go back. A, B, C, and D. D is holding 10% shares. D doesn't have a board right. Okay. D doesn't have a board right. Then how would D get to know about the company? Right? Maybe as a shareholder, it will have some rights. It can maybe inspect the registers, maybe whatever is there under Companies Act. But it can't have all kinds of inspection rights. It can't just barge and ask for information. But it may still want, maybe D is a fund, it may want to have certain information rights. It may want to inspect. It would want to know how the company is doing, right? How would it get it? Because as a shareholder, maybe you may not have those kind of rights, right? All you would get is financials, maybe. You may not have that kind of inspection right. So information and inspection right is something which maybe is in a shareholders agreement, which maybe you'll peg at a particular percentage. You'll say that till the time D has X percentage of shareholding, D will have a right to ask for the following information from the company. And the promoters will be obliged to give those kind of information to the company, right? And typically those kind of rights will be pegged at a certain percentage. Pegged, when I say pegged, it means that there will be a follow away threshold. That till the time you have XYZ percentage, you're free to come and inspect the books. You're free to ask for XYZ information. Okay. So see, broadly, I have tried to discuss the key aspects. Obviously, it's not possible to discuss everything, but I hope this so far it has been a fruitful discussion. I can wait for a minute or two if you have any questions, or you can feel free to let me know if this discussion has been useful, or any specific recommendation on anything else which needs to be discussed in the next session, or right now also, because we do have 5 minutes left. I can just wait for a minute.
Thank you so much, sir, for your valuable insights. I've got a few questions from the individuals, and if you permit, I would like to ask on their
Sure.
behalf. So the very first question which we have got is, what are the scenarios wherein the buy-sell agreement can be triggered?
What a scenario in which buy-sell agreement
can be triggered, sir.
Buy-sell.
Yes, sir.
I think the gentleman who asked is referring to a share purchase agreement. It can be in any situation. If I want to, let's say A, B are shareholders, B want to sell its shares, A want to sell its shares, right? Then obviously C, whoever is purchasing shares, would buy shares from B, right? Obviously, if I'm buying shares, your shares, then, and I'm not privy to the kind of company you're running. I have no idea about your company. right? In that case, I would want certain reps and warranties. Okay, I am now becoming part of the company. I'm buying shares from you. I would want you to give a rep that the business has been run in a legal way. So in the such scenarios, you would want to execute an agreement. At the same time, the person who's buying shares would also want a rep on the title of shares. If she is buying shares, she would want B to promise or commit and warrant, give a rep that title on shares are perfect. B is the owner of shares. Okay, that's why you would need an agreement. You can't just
Yes,
rely
sir.
on a verbal agreement.
Yes, sir. Sir, apart from that, one another question which has been asked is what happens when a shareholder agreement does not contain any provision related to dispute resolution?
Yeah, if see, if there's no provision on dispute resolution, parties can are free to avail civil remedies and approach relevant jurisdictional court. Dispute resolution usually will have mediation, arbitration, or maybe say that parties can go to XYZ court. But if there is no this thing, then let's say the company is registered in, let's say, in Delhi, cause of our action arose in Delhi, let's say, right? Parties have executed the agreement in Delhi. You can go to the appropriate forum and seek a civil remedy.
Okay, sir. Thank you. The floor is open for the questions. The participants are requested to ask the question as in when the question arises. We'll be waiting for 1 minute.
Sure. I think someone had asked that whether AVM matters are shown to shareholders at the time of the agreement, or all companies have list of some matters, or is it made so AVM list is a commercial matter which is agreed between the shareholders. It's not a fixed list of matters, just to clarify. If I am the new shareholder, I am getting AVM list, I would want to have a long list so that I can control the company. There's no fixed list of matters. I just give an example of 3 matters. You can have any, you can have 40 items: change of name, change of registered address, merger of a company, taking of loan, initiation of litigation. I can give 40 examples just sitting here. You would want, the person who's getting AVM would want the list to be longer. The company would want the list to be shorter because the company will have to take consent. It's very logical, right?
In closing, we extend the heartfelt gratitude to Sir for accepting our invite and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. Thank you so much, sir, once again, and we eagerly anticipate the opportunity to host you again. Thank you, sir.
Thank you.
Thank you so much, sir.